Hello, writers and readers. I'm freelance fiction editor Miranda Darrow, here with my weekly video about writing, editing, and the writing life. This week, we're talking about copyright and fair use for writers. First, a caveat. Although I am a practicing attorney in my day job, this presentation on copyright and fair use does not constitute legal advice. This is not my area of legal expertise, and my goal with this presentation is just to familiarize writers with the concepts that I've encountered as a writer and as an editor. So first up, what's the difference between a copyright and a trademark? Copyright protects original works created in a fixed form, including literary, dramatic, musical, artistic, and certain other intellectual works. A copyright applies at the time of the creation by an original work, but authors, composers, and artists are better able to prove that they are the rightful owner by registering their copyright in the United States with the U.S. Copyright Office, which is available online at eco.copyright.gov. If you're in a different country, I don't know anything about that. Trademarks, on the other hand, protect words, names, symbols, sounds, or colors that distinguish goods and services from those manufactured or sold by others and are used to indicate the source of the goods. So the U.S. Patent and Trademark Office reviews applications to register trademarks for business names, slogans, logos, and other items that brand the company or product. This includes the colors and the fonts used and requires a search of similar marks prior to filing. It's a complicated process that involves hiring an attorney, not me, because I don't know anything really, but intellectual property law. But I know it's a complicated area. So what's the difference between the copyright and a trademark? If you think of the musical Hamilton, the song Wait For It is a song that is subject to a copyright. It's an original work of music. The play itself is a copyright, as that is an original work of theater. And the logo for the production could be subject to a trademark. That's the one where it's the star and the missing part of the star is Hamilton standing there like that. So that with the black and the gold and the font that they use, that could be a trademark. And in fact, it was a trademark because there was a case about it where someone was doing a similar style for a play that they were putting on in Iowa about the gubernatorial race or something like that. And then they defended it and said it was a parody. Anyway, so that's a trademark. The content of the art that was produced for it, the written, the screenplay, the songs and stuff, those are copyrights. All right, another concept that you need to use, that you should know about in this area is public domain. What is the public domain? This term refers to works that are not subject to a copyright, and it could be for any number of reasons, and it's usually the age of the work. Anyone can use public domain works in their own derivative works without having to pay for permission. There are four main reasons that works fall into the public domain. The first is the copyright has expired, but for those things, it's old. The second is the copyright owner failed to follow copyright renewal rules. Third, the copyright owner deliberately placed the work into the public domain, a process known as a dedication. So for example, Creative Commons. The fourth reason that something could be in the public domain is that copyright does not protect this type of work. For example, titles, short sayings, and concepts. So there was a lawsuit a couple of years back where a romance author had claimed that she had a copyright over the word cocky in a series of books and was issuing takedown notices for any other romance authors who also had the word cocky in their titles of their books. And the romance community went up in arms because you cannot copyright a title, you cannot copyright a word. Titles are not copyrightable. And so if you're writing a book and you want to talk about a song, use the title. But it's much more perilous and risky legally to use the lyrics because the lyrics are not too short to be copyrightable. As of 2025, when I'm recording this video, the copyright in the United States has expired for all works published in the US before 1930. If the work was published before January 1st, 1930, you are free to use it in the United States without permission. Note, for works published after 1977, a very different rule applies based on the life of the author rather than a simple passage of time. For works that are originally published in other countries, you got to check there. And if you're not in the United States, you also have to check there. For US works subject to copyright, persons wishing to incorporate such works into their own productions must seek permission from the copyright holder or follow the limitations set forth in the fair use doctrine. So what does it mean to get permission? I was at a conference, I was at Killer Nashville, and I was on a panel about legal issues for lawyers. And one person had said, but if I'm citing it appropriately, then I can use it, right? And it's like, no, if you're following MLA or any of the other AP citation styles or CMOS, that does not give you permission to use copyrighted works. That just says if you are citing it in like a research paper or something else. Permission is if you want to make a commercial use of it, you have to seek and usually pay a royalty or a license fee. Sometimes people will give you permission if you explain the use. I contacted the author of a book with a concept that I wanted to reference in one of the books that I was working on, and they granted it to me. And I printed that out and I kept it with it. For more information on public domain works, use fairuse.stanford.edu and search that for fair use. What is fair use doctrine? It's a legal concept allowing consumers to reprint and publish portions of copyrighted works for limited purposes. When you're considering and evaluating whether your use is the fair use, some of the things that you want to think about it, is it commonplace? Or is it features that are only found in that work? Like the concept of a meet cute in a romance, or the discovery of a dead guy in the first chapter of a mystery, those are very commonplace. How much of the work is used? Less than 10% is usually pretty safe for fair use, but barring anything more than that. So this means that shorter works like poems and song lyrics, it's really hard to claim an entire stanza. Is the part you are referencing considered the main selling point of the other work, the heart of the concern? And another consideration, is your work going to compete against this work in the marketplace? The next concept we're going to look at is parody. Parody is a recognized fair use of copyrighted material. Parody is when one piece of work, the parody, imitates a serious piece of artwork, literature, music, etc., for a humorous, satirical, or critical effect. There's a free speech argument in support of parody, and it also support in the fair use exceptions to the Copyright Act. Notable cases on parody include music, the seminal case of Roy Orbison versus Two Live Crew. You cannot make this stuff up, in which Roy Orbison sued Two Live Crew over sampling Pretty Woman in Two Live Crew's also called Pretty Woman's song. Children's literature. Dr. Seuss's estate was attempting to take down a Cat in the Hat parody about the O.J. Simpson trial, The Cat Not in the Hat. Cat in the Hat, O.J. Simpson parody, and photographs. Annie Leibovitz sued the makers of the Naked Gun 33 1/3 advertising campaign, which used a photo that she had taken of Demi Moore while pregnant and had a parody version of that for their ads. So parody exception has its limits. Many successful parody artists seek the permission so that the original artist is in on the joke. Musician Weird Al Yankovic, one of my very favorites, declined to parody Prince when he requested Prince's permission. He never did. Prince was not cool with that. Weird Al attempted to get permission from Coolio and had permission from the people who would own the rights to Gangster Paradise when Weird Al recorded Gangster Paradise. But then he found out later that Coolio did not like it, and he apologized to Coolio, but he had already received the permission. Weird Al also requested Paul McCartney's permission to do a parody of the Bond song that McCartney wrote, Live and Let Die, and he wanted to name it Chicken Pot Pie. And Paul McCartney had said, I don't disagree with the idea, I disagree with the turkey because he's a vegetarian. He would have been okay if Weird Al had recorded Tofu Pot Pie. In a weird piece of irony, Weird Al wrote the parody song Word Crimes as a parody of Pharrell Williams and Robin Thicke's Blurred Lines. And Thicke and Williams's Blurred Lines was sued to the name of $5 million as a copyright violation of Marvin Gaye's Gotta Give It Up. So parody is a lot safer than just sampling. And the other musical one that I wanted to mention here is John Fogerty was once sued for violating copyright by sounding too much like John Fogerty. So John Fogerty, when he was a young man, was a great songwriter and not a great contract negotiator, and had signed away his rights to the songs that he'd written while with Creedence Clearwater Revival. And then in the 80s, when he was trying to make a solo career, his old manager, whoever had the rights, sued him and said that Outfield sounded too much like Old Man Down the Road or something like that. And his defense to the court was, yeah, it sounds alike, because I'm John Fogerty. And he won. They said that selling the rights to one song does not prohibit the man from being able to make a living selling songs. Please note, this discussion is not legal advice. Consult an attorney if you have questions about copyright and other legal issues, but I thought you might be interested. And if you enjoyed this video, please like, subscribe, and share. I post new content every week about writing, editing, and the writing life. This is freelance fiction editor Miranda Darrow wishing you happy writing.